Okay. On a resumption of RC 446 of 2020, the witness, you are reminded that you are still under oath, Mr. de Klerk. Thank you.
Thank you.
Thank you.
During the state's case, the state's ballistic expert handed up what in essence is 7 photographs, charts. In fact, he didn't explain what he found in these charts, simply to say that his conclusion was that the firearm fired the Cartridge case in question. Is that correct?
That is correct.
You have the similar charts. I want you to go through them and give us your expert opinion.
I'll do that.
Whether this conclusion is correct.
First thing that you will notice on the court charts, I marked them 1 to 7, and I've examined all of them. And so I'll go through the first 2 court charts, court chart 1 and 2. Can I just ask the court indulgence? Is a problem? Can't seem to.
Do you want to enlarge it?
No, I can't. The problem with the court chart, or my, it doesn't want to play the way that it's supposed to play. Yeah, I've got it. Sorry, ma.
Yeah, it's saying the connection table.
It should. We should have a.
Quite an image problem.
Okay, here we go.
I'll do it this way.
Okay,
The
I
first-
just want to remind you that while I'm writing, I'm also going to have to look, so it's going to take a little bit longer, all right? Okay, thank you.
I enlarged it. And both photographs in the court charts depict the same comparison visually found. The only difference is that the second chart of the Cartridge case was rotated and tilted slightly downwards, moving the striations. It's exactly the same mark. The chart indicates the best possible match viewed at this area by Lieutenant Colonel Magodeleka. By examining the striations as depicted in these charts found on the neck, one can clearly see distinctive striations that could have been used for a better comparison, which is also visible on the right-hand side of the cartridge. Examination of the striations that indicate similarities. Is it clear that some of the striations are also different in size and depth, etc., and are indicative for an individual characteristics? If one look at the depth and size, I'm showing you at the bottom, as well as there at the top.
Please speak up.
There's differences. So it appears to be the same, but if you, by closer inspection, you'll note that there is slight differences. That's also visible. Then I go to court chart number 3 and number 4 and number 5. Again, we have the same thing with court chart number 4 and number 5. It's exactly the same mark again. That's photograph depicts in the two photographs. The chart indicates a possible match viewed at this area by the Lieutenant Colonel. The marks indicated appears to be similar, but by closer inspection one will notice that the angle of the marks are different, indicating a possibility of subclass characteristics, which Lieutenant Colonel Matuguleka did not consider in his examination. And he testified to the effect that currently in Port Elizabeth, the ballistics unit do not use subclass characteristics. The striations for a better same source identification are not considered or overlooked. We can't see this. You need to make notice of, if you look at this mark to that one, it's different in appearance. This looks more like an angle, which this one is more a little bit flat, straighter. If you look at the top one, the same appears. You've got like a curve. Curve is not there. If you look at this one, you'll see that the curve is also flat and it's not as steep as the other one. Examining the striations that indicate similarities, it is clear that some of the striations and marks are also different in size, depth, etc., and are indicative for individual same source identification and was not considered or used. These are all differences on the blue arrows.
So you say the blue arrows indicate all difference?
There's also differences, yes, which is not on the exhibit case. I just want to show the court there's a thin black line in the center. That's the center line of the microscope. When you look through, on the left-hand side is your exhibit, the one that was picked up, and on the right is the test that the colonel fired in this firearm. By comparing the marks found, it is very important that the marks must be considered as possible subclass characteristics and should first be eliminated before going over to the individual characteristics. Shall I continue? Then we're looking at court chart number 6. Illustrate a striated mark that appears to be similar in size and depth. This striated mark was most likely caused by either the feeding or the ejection process. So in that process, this is when this mark was created. The test cartridge depicts a second striated mark, which is clearly different in size and depth on the exhibit. 2 more striated marks are also visible, which again is absent on the test cartridge. There's 2 markings there as well, which is not on the test. That the striated mark was matched correlated by the manipulation. The reason being, the cartridge do not line up. The light source are most likely not at the same angle or height, casting shadows differently, causing the marks to appear similar. You can see it there at the top with a white arrow. So you have the appearance that the mark is the same or similar. Let me take the last court chart 7. It's my submission. The striated and impressed marks that appears to be similar. All those blue arrows, it looks the same. And it's my submission. This is the best court chart illustrating a possibility of a positive same source identification. However, these differences is also noticeable. All the yellow arrows, differences. All examiners considering world standards and protocols and work ethic, it is important to consider all aspects, class characteristics, subclass characteristics, and individual characteristics when comparing evidence relating to same source identification. I just need to clarify, the same source identification means that the tool that was used. In other words, we have the firearm, so the tool becomes the firearm and the cartridge is the object where the marks was transferred to. So you have a tool making the firearm and you got a tool, firearm becomes the tool. Same source identification in one area using one tool would be a fatal flaw in the examination process as well as the conclusion. Now, since I've been in the ballistics unit, it was always said you need to follow up. Always. And the rule of thumb, follow up. In other words, if you find striations that's similar, since I've been at the ballistics unit from 1989, but it has been drilled in you, you have to have a follow-up. And the Lieutenant Colonel actually testified that he followed up. But he used the same tool, same area. And that's where the problem is. He had to find something else. Now, on the comparison, this is all the marks that you can find on a cartridge case. He testified that the firing pin is negative. Of the particular cartridge, he said it was negative. The extractor was negative, the ejector was negative, and the breech face mark was negative. That cartridge that he found was negative to the firearm. I divided, like I testified earlier, the chamber and neck mark, I divided them in two. He didn't use other chamber marks. He used neck marks, or neck chamber marks, which he made positive. Ejection port, he didn't use that. Magazine lips, he couldn't find or didn't use it, or the lead and groove, he didn't use. So this is just an illustration to show the court. Out of all the marks that he could have found, he only used the neck chamber marks. Now, according to me, according to standards, world protocols, you need to follow up with a second tool. You need to find a second tool to make it, especially on firearms. At least two areas. Due to this fact, according to world accepted minimum standard based on evidence and testimony currently in front of this court, relating to same source identification, a positive identification cannot be made. If you go look at the protocols over this in the world, according to those protocols, this would warrant that you cannot do a positive identification by just using the neck marks. According to the evidence, all firearms were collected from examination and comparison. And Lieutenant Matagoleka could not match any of these marks to any other firearm internal parts. None, with the exhibit fired cartridge case. The assumption is now made that Lieutenant Colonel Matagoleka could not find any other individual characteristics of possible matches or non-matches, irrespective of how small or irrelevant they might have been. So if you go look at all the marks that was available to him, he made it negative. So if you go look at the explanation or elimination, the definition of it, he created and said it's negative. And out of those, all the other firearms, he couldn't find one striation, not one little line that matches up at all with any of the other firearms, which is the same. The class characteristics will be the same. It's the same firearms. The models are the same. The serial numbers follow each other. The last time we were in court, we asked permission to take photographs of the exhibit cartridge case. And I've taken this photograph myself, these photographs that I'll show now. And I used the Samsung S10 phone taking a photograph. And this is on the side of the cartridge case. This is the exhibit that was picked up. There's a mark. This was most likely produced when the cartridge was ejected. Let me go further. If you look here, this is there, you can actually see where it's marked. And here you can see other marks available. Here you can see the extract or ejector marks is here available. He made that negative. Then we're looking further. There you can see that mark again, a little bit clearer. Still marks here also. Here as well. This is the breech face at the back. And all I need to show the court, this is where the breech face markings tend to, sometimes you'll find it on, but this is very hard. It's harder than your primer. The primer is softer. Now, after theory of identification, and the court don't have to write down, I'll give the court a copy of what I've got here. Pleasure. All I want to basically highlight is the theory of, I'm going down, the theory of identification as the pertains to tool mark enables opinions of common origin to be made when a unique surface contour of two tool marks are in sufficient agreement. Now, this document comes from the AFTI training manual from 2024. The sufficient agreement is related to significant duplication of random tool marks as evidenced by the corresponding of a pattern of combination of patterns of surface contours. Significance is determined by the comprehensive examination of two or more set surface contour patterns comprised of individual peak, ridges, furrows. It goes further and then it explains you need a second set of markings. He used the same tool or the markings that the tool that produced the markings that he photographed was one tool of the firearm. Then out of the video,
just stop there. I just need to clarify something. Do you understand correctly what you're saying? You could not have made a positive match, correct?
that is correct.
Because
He didn't have the necessary follow-up.
he found
prototype-
neck marks on two different places instead of neck marks, plus maybe the extractor, the ejector, or something else.
That is correct.
And that is the international standard, is it?
That is correct.
And in any event, We just go back. Your observation of the charts indicate that you shouldn't have even made a positive match on the neck mark.
There's a lot of differences which I would have. I didn't examine the actual cartridge, but there's definitely differences that's visible that would warrant not a positive identification. I would rather have made it undetermined because there's so many differences that I can also see. And that's where the subclass characteristics, you first need to go look at the subclass characteristics and which of those marks are unique to that particular firearm. And based on that, only then can you make an identification. But now it's same source identification, so you have one tool. To follow up and actually get a positive identification, you need a follow-up somewhere else, different area. You cannot use the same tool.
All right. Now, this you're putting up here appears to be a person standing with a fire.
With a firearm, that's correct.
Is this the flash?
That's my instructions.
All
So what
you conducted flash tests on a blank gun, is that correct?
That's correct, I did.
You made a video of these tests.
That is correct. I'll show the video a little bit
You
later.
play it fast, please.
Okay, can I just...
Fine.
Connection problem on our side.
Coming?
It's coming.
It's there.
Yeah, carry on.
Okay, playing the video.
Sound is very...
Yeah, sound is very well.
Got to put up the sound, please.
Well, I've tried. Let me try this. It's loudest that it can go, sorry. The video.
Right. Take us through what you're doing there.
Now I'm explaining the cartridge. It's a 9 by 22 millimeter. It's a blank cartridge. You'll see now I'm going to the back and then I'm going to shoot. I think it's 5 shots and it's in the dark. There's also a backlight. Unfortunately, the camera that we use, but you will see the blank. I will make this available to the court as well.
Play it again.
Can you just play the firing mechanism?
Try and pause it.
Must I pause it?
On the flash.
I'm going to see if I can
Okay.
try it.
Past the strings. All right. Is that it?
Okay.
Tell me. It's probably a leg question. If you're comparing fingerprints, you probably have 7 points of similarity. Correct?
That's correct.
The before an expert can say that it's the same.
That's correct. And normally what will happen is they will mark out 12 points and not just 7.
What happens in ballistics?
Ballistics, there's no limit. There's no limit. There's no, to say on a scale of probability, you've got to have 10 lines or 10 striations. That's the same. There's no limit. If the mark is unique enough, it can be used.
But you require 2 separate places or 2 separate tools.
That's
before
correct.
You can
Yeah.
make a positive find.
That is correct.
Is that what you say?
That's yes.
And this is a standard that you say is universal.
That's correct.
Now, in appearance, we have the blank gun. We all agree in appearance that it's very similar to the original. In fact, it's the same.
That is correct.
It is available if my little friend for the state wants to pull it out and everything.
I can pull it out if you want. I've got photographs of examples as well.
Will you show us the photographs of the example? I didn't.
He was going to pull out
My
the fire.
my lady's a bit nervous of the gun.
Not at all.
There we are. All right.
Now, all of these that you can have a look appears to be the real thing, but only 2 of them are real. The rest are all blank or airsoft guns. So this one,
Let me guess which ones are real.
this one is real. The second one from the left,
Wait.
and this one is real. This is the only thing. What I would like the court to notice is that the carrier handle, the back of the stock, the A-frame at the front. And I've taken a photo, I enlarged this photograph just to show the serial number and the caliber. In South Africa, when they manufacture these are chambered for 5.56, but because of the law and ammunition, they put in 223 as well, because you can fire both of those calibers in this particular firearm.
Tell me, we saw when the colonel was firing tests with the real gun, it continued to jam.
That is correct.
Why was that?
Well, guess as good as mine, but probably either the ammunition was wrong that he used, or the firearm was dirty.
223 used in a 5.56,
Yes,
and the other way around, would that
same thing.
cause a problem?
Yes, especially 5.56 fired into 223 caliber firearms. Yes, this is manufactured for 5.56, so I suspect that firearm was either dirty or the ammunition was not 100% correct.
Right.
I'm not clear on his explanation now compared to saying you'll see printed on the enlarged photo 223 and then 5.56. Now, the explanation based on what he said there, I'm not following you. Or him. Let me put it to you that way.
It was about the test done by the colonel.
I know now he's saying that about the test of the colonel, but his evidence prior when testifying about the enlarged...
He was just saying that he's taken a close-up to show that it's a 5.56.
South African made ones is showing, and that you can use the 223 and 5.56. No, I can't bring that to his explanation now. Maybe if he can just...
It can be fired in both guns. It's just that
Yes.
it does cause a problem in the one type of gun. It can seen when nothing turns on. Nothing turns on it. I shouldn't have even raised it. Nothing turns on. All right. The ejection of the cartridge case. You also did tests on that. Is that correct?
That is correct.
And if you can put those photos up of the RC stadium. Yeah, this is it. We apologize for the left-hand photograph. We struggled to reduce it. This is the witness who was pointing out where she found the cartridge case.
That is correct, and you can see there where the X is marked.
And we've established that where she was standing would have been in fact a tent
That is correct.
for food.
And that is the end of the stage. If you look where she was in the evidence, this was given to her, the photograph, and she marked out the X and said this is where she found. Now if you compare that to photograph 8,
I think it's common cause, and it's not in dispute, obviously, that the firearm ejects to the right, and I can't recall the exact meterage. I don't think that was a challenge.
it's less than 2 meters to the right. To the right.
So, if that cartridge case was there, had been ejected from the firearm would have to be within a 2-meter radius, so that's not.
That is correct. I would have expected if somebody was standing here firing, that you'll find the cartridge case should probably most likely be either to the left, or if you look at the,
Of course, another possibility, is more than likely probable, that that cartridge case was not fired there, but somehow landed up.
that's also true.
Alright. I don't know if I've forgotten anything. Think
No,
of
not
anything?
that I can think of now.
Thank you. Let's just go back now to your report. Sorry. Paragraph 6 and 7. Relate to a test that you were requested to do on
That is correct.
the same firearm SP A 237, 245, 246, and 248.
That's correct.
The one in question, the
239.
is which one?
No,
No, the one we've got here in court is allegedly fired. What is the number again? Just
I think it's 239
239.
/14.
Isn't it
248. No, it's 248. It's supposed there's a typing error in here.
So 245, 246, and 248.
Yeah,
Was the other one not 247?
can be.
All right. You tested these firearms, is that correct?
That is correct.
Nothing turns on it in this case. And you later explain the method used for testing.
That's correct.
Explain the microscopic examination in paragraph 12. And there you point out
Yeah, all the markings,
why don't
yes.
ballistic people ever put numbers on your page?
Yeah, we don't.
Anyway, I'll show you this one. This is right at the back of a PMP 223 Remington. You point out where marks are found on the cartridge case of that.
That is correct.
And then you come to your conclusion that you've already testified about. Is that correct?
That is correct.
Thank you. You confirm this report.
That is correct.
You confirm that the presentation you've been given before court is part of your evidence, and you can put it onto a USB for the court
That is correct.
to watch in random whenever they want.
That's correct.
Mr. de Klerk, the blank firearm is available in court. You've examined it, is it correct?
I've examined a blank. I don't know if I examined this one, but yes.
And the one that's here fires in the manner that you showed in the video there, is that correct?
That is what, the serial number. I've actually written down what it was.
And if you have regard to what you saw on video and the test that you've done, would you agree that the blank firearm looks exactly the same as the actual firearm?
That is correct.
And that it would be very difficult to discern the difference from a distance between the real and the blank firearm.
That is correct.
Now, when you did your testing on the actual Norinco rifle that was there, what was the maximum range that it could eject once it ejected the...
Still stayed within 2 meters from where you were firing.
So it
To
was-
the right, about let's say half a meter to a meter, and 2 meters away.
So it's to the right, backwards, or to the rear, with a maximum of 2 meters, is that correct?
That is correct.
Now you're explaining the difference between 223 and 556. I put you that there's a very, very small difference that one can't even see with the eye. If one looked at the rounds unmarked, would you agree with me?
That is correct.
For an expert like you, the difference would be the primer. One was a burden primer, the other was a boxer primer, but you don't see that from outside of the cartridge.
No, that's normally your 556, your military ammunition will be a boxer, or burden, which has 2 little holes, or flash holes on the inside of the cartridge. And your reloadable, your 223 Remington will have 1 flash hole or 1 hole at the back.
But to a person looking at the rounds, they look exactly the same.
Look the same. If you don't read the head stamp and it says 223 Remington, on your 556 you will have a date and a number. That's basically all. It's going to have 2 sets of numbering.
And the actual size is minimally different that you won't see with a natural eye, so much so that you can fire them, in most instances, interchangeably between the different firearms.
You can't fire them in different fire or different caliber fire. 223 you can fire in 5.56, but the other way around you will tend to find that if you shoot 5.56 into a 223 chamber, it will get stuck. Most of the time. It doesn't happen always, but it can happen. We found that there is problems, especially if you differentiate between the calibers.
You've been in court, you've watched the evidence, you've participated since the beginning, and I just want to put the following objective factors to you. This alleged incident took place at a packed stadium. Would you agree with that?
That's correct, yes.
There were many eyewitnesses present for this celebration. You were aware of that.
That's correct.
Not one of those eyewitnesses complained of any firearm being discharged. Would you confirm that?
That's correct.
Only above that, there's been no complaint of anybody feeling that they're in danger of having been shot on account of a firearm being discharged in a public area. Would you confirm that?
That's correct.
You've seen the video, you've watched the shooting. You don't see anybody running for cover, do you agree with me?
That is correct.
You what?
That is correct.
We've been here for years now. We haven't heard of one eyewitness that watched the actual shooting and expressed any fear. Even the gear house people that were there never expressed any fear of having been struck. Would you confirm that?
That's correct. Confirm.
Over and above that, and this is where I'm going to come to your field of expertise, we've heard that there are 5 SAPS VIP Protection Service members on the stage at the stadium at the time. You've spoken in your report of your extensive experience in the SAPS. What were they required to do if they were there and actual rounds had been shot at the stadium?
Well, they were in charge, according to my knowledge, is they're in charge of a VIP protection unit and was allocated to Mr. Malema to look after him, or accused number 1, to look after accused number 1. And their objective is to safeguard him, but if there was any firearms fired, I would have expected the police to actually intervene.
By intervene, you said put an end to it and take the firearm away and possibly arrest people if they...
That is correct.
Now, we've heard from the investigators that those police officers made statements But there's no mention of anybody having intervened or done anything to resist any firing of a firearm in a public area. Would you confirm that?
I've had access to the statements, yes, I agree.
Now, drawing on your last slide that you showed us, those two slides together, with the point where the cartridge was found, which was put to you by my learned friend, was under a fruit tent. You're aware, having watched the trial, that there was no damage to any of those canvases or tents, is that correct?
That's correct.
Is there any possible explanation for how that cartridge would have got there at that distance and with all those structures in place?
There's only two possibilities that I foresee. First of all, that it was moved and dropped inside the tent. And the second option is when the stage was broken up, it could have been kicked up to the point where they found it. That's also a possibility.
You speak of two possibilities. I want to put to you, so if it had been there before the celebration, it would also be a possibility.
That's also a possibility, yes.
If it was placed there after the celebration, is another possibility.
It can be planted as well, yes, I agree.
Put somewhat differently, it's not possible for you to say when that cartridge was actually placed there. Do you agree?
No, you cannot determine that. No.
But one thing's quite clear, and that we're going to put to you, so is a person standing on the stage where you saw accused number one, if such a person fired a real bullet with a cartridge that was then ejected, it is not possible for it to have traveled to that distance purely from being ejected. Do you agree?
No, it's not possible.
You're also aware that there were no touch DNA traces or fingerprints that link any of the accused to any of these firearms or ammunition. Is that correct?
I don't know that, but I can't dispute that.
You also have heard that there's never been any powder residue tests conducted on any of the accused to place them on the scene or in the vicinity of a firearm being fired.
That is correct.
You were also present when Sergeant Becker explained that he had reconstructed the scene to ascertain where the spent cartridge had been picked up. You were present in court.
That's correct, yes.
Was it in any way possible for that cartridge to have got you there on his reconstruction from being ejected by a rifle at the time?
No, it's not.
So may I be permitted to turn to both my client, the accused, and my ex-witness to see if they have any other. Thank you, sir. No further questions. Thank you.
This stage, it's a late hour. I also advise to consult with Mr. Badleka as well. He's present relating to the evidence. If you can hold him until tomorrow.
I've got no objection. Unfit.
There is also, it's only fair because you need to anticipate this. We're not unfair.
Or any of this evidence.
Would your worship like us to download this for you and give it to you? Or after the...
Even if it's after, I'm more interested in the content of his evidence than the actual visual. That's where, yeah, I would appreciate any. Both of them would be wonderful. Okay, may we just pause the record, please? Seems as if Advocate Caesar is in great distress. Go, go. Please, Mr. de Klerk, you can stand down because when we come back, we will just do the postponement. I know Advocate Caesar is not here presently, but with Advocate College, yourself, and Advocate Oudis, Mr. Levitt, I wanted to say Lewitt, just I just want to discuss time frames with you for tomorrow, because obviously this matter, I was running 2 courts today. So I want to know the time frames for tomorrow so that we can be on the same page. Okay. But if Caesar is back, just shout and then I'll come. Thank you. We'll just adjourn for him. Thank you. Okay. Thank you. Accused 1 and 2. The matter then postponed for cross-examination by the state until tomorrow, 19 June. We will commence in the same court, Regional Court 4, at 9 a.m. Thank you, bail extended. Thank you. You may take a seat or stand down. Sorry, Advocate Caesar, while you were out, I just asked to have a brief word with parties so that I know as to how to run my role for tomorrow. Because of today, I juggled, so I just need to know how much I must juggle tomorrow. Okay. Thank you. Court will adjourn.
This one. This one looks like an extension. Bongi? This one. This one or not? This one. Bongi? This one. Which one is this? Is it Bongi?
And I made a presentation both personally and on behalf of the South African Gun Owners Association to Parliament in 2000. concerning the structure and the content of the Act. From 2000 to 2004, I was part of the civilian component that helped draft the regulations to support the Act. Where I worked closely with the South African Police Services, legal services. From when the Act was promulgated in July of 2004, I've been involved in numerous processes concerning the Act. Most recently, in May of 2023,
Can you just,
my apologies,
please,
my apologies,
just,
Your Worship.
Okay, I'm with you from since the Act was promulgated in 2004. You were involved with
numerous processes, both judicial and parliamentary. The most recent of which was that I made a presentation to Parliament in May of last year to the Portfolio Committee on Police on behalf of the South African Arms and Ammunition Dealers Association, where the Minister, Deputy Minister, National Commissioner and various other senior police officers were present. I did that at the request of the chairperson of the Portfolio Committee. I was also a panelist at the Firearm Summit held in 2015 in Parliament by the Portfolio Committee on Police. And I most recently appeared with counsel in the Constitutional Court in 2022 in the matter of fidelity versus the National Commissioner, the Minister and others. Concerning an interpretation of the Firearms Control Act. I broadly speaking represent a large number of different components of the firearm industry in my capacity as an attorney.
Would it be correct to say that you represent the security industry?
Yes.
We are concerned in this particular matter with tactical security services situated in the Blood Reserve. Are you aware of this company?
I am.
Have you had dealings with this company?
Part of my practice involves the obtaining of firearm licenses for security service providers. And in that capacity, I have made applications, prepared applications on behalf of tactical security services.
Would you say that you are...
sorry, I didn't make this. What's known to you and him is new for me. Just a second, I'm nearly there. I have prepared,
firearm license applications.
On behalf of tactical.
Correct.
If you could just, in broad outline before we deal with the specific matter, explain to the court how a security company would go about obtaining firearms for their security guards and the procedures that are used? If it is that simple.
Once a company is registered with the Private Security Industry Regulatory Authority, CIRA, it is automatically accredited to own firearms. That company must nominate to the police a person who is responsible for making the applications, for the firearm license applications.
If we just hold there, I have a document which unfortunately I sent off to get photocopy, but we can simply refer to the evidence of a Mr. Stander, who has testified for the state from CIRA, that has indicated in his testimony, as well as the evidence of the Lieutenant Colonel Janssen, that the person appointed or the responsible person for tactical security services was Mr. Clement Nduli.
I checked my records personally, and Mr. Ndululi was the responsible person according to the documentation that I prepared in 2018, and he was also the member of the closed corporation in 2018.
Tactical Security Services was a closed corporation.
Correct.
You can use it loosely as saying it was a company, but that's not 100% correct. Okay.
Yes.
Mr. Nduli, Clement Nduli, he was, I suppose, the majority holder, if we call it that, of the closed corporations.
I don't know what his membership was, but he signed the application in his capacity as the member.
Okay. Now, let's follow the procedure that would now happen. You say that once a company like this or a closed corporation is registered with CIRA, it automatically becomes entitled to acquire firearms. Is that correct?
The word is accredited, yes.
Accredited. Okay. We have heard the evidence of Mr. Stander that tactical security was in fact accredited. And I'm sure you picked that up during your application for firearms on their behalf.
They had to be because they were granted firearm licenses.
All right.
They were?
They were granted, their licenses were approved. So they had to be compliant with that accreditation.
We've also had the evidence of Lieutenant Colonel Janssen about an inspection done at tactical security, about the books that were kept and all the registers that are required to be kept by a company, or let's keep using the word company, like that. You're aware of that?
I'm not aware of the specific inspection, but police regularly inspect the books.
Now, I am the new security guard, and tactical security now wants to arm me because I'm going to be guarding an ATM. I want you to tell us the steps that need to be taken and the permissions, etc., and who is responsible for the firearm that I'm eventually got now in my possession.
The individual security officer has to be registered with CIRA, the regulator. They must have a competency certificate to possess a firearm.
Yes.
They must have completed additional training known as the business purposes training. In order that a firearm be given to that security officer, he must be in the employ or service of the license holder. The responsible person or someone delegated by the responsible person signs the firearm over to the security officer by way of an entry, a written entry, into a daily working firearm register. The security officer co-signs that they received the firearm. And then the security officer is issued a permit by the responsible person or someone delegated by the responsible person, which is a temporary license in effect, to possess that firearm on the conditions, according to the conditions stated on the permit.
I'll show you a document dated the 13th of March 2018 from the Statutory.
I noted.
Can you just repeat the March 2018, but was there a date?
Dated 13/3/2018. Unfortunately, I've asked for it back because we were on our way to make copies of it.
Do you want to go make copies
I will
of
read
it?
it into the record. I think that's the easiest.
So I can write as fast as you read.
No, doesn't matter. I can understand.
Not a problem.
I'll read the first two lines because that's what is of relevance here. It says the responsible, this is a warrant officer, A.M. Small from Brighton Beach, designated firearms officer. I will also show my learned friend the document. It says the responsible person for the safe handling and proper handling of firearms is Mr. T.C. Mbuli with ID number 760321 5498084, who is in possession of a relevant and valid competency certificate to handle and use all categories of firearms in possession of the above security company. You read this?
I have.
This coincides with the evidence or corroborates the evidence of Lieutenant Colonel Janssen, who himself testified that Mr. Mtuli was the responsible person for firearm compliance and tactical security. Now,
If I may just put that slightly differently, Your Worship, if that were not correct, tactical security would not have been granted the firearm licenses in 2018.
why we are going through this exercise is because of the provisions of Section 120.10a of the Firearms Control Act, which is count 6 in this matter. And this section, the charge against accused number 2, and I'll read it to you. It says that on about the 28th of July 2018, at near the Caesar Ducasse Stadium in Mdantsane, the accused had unlawfully supplied or in any other manner give possession of a firearm and or ammunition to wit a .223 Narinka rifle and or a firearm the make of unknown to the state and a .223 Remington bullet to Julius Malema, the accused number 1. Now, what is important here is this section. Did unlawfully supply or in any other manner give possession of a firearm. Now, if I could just, before you reply to this, tell you that in a request for further particulars, the state was asked in what manner it alleged that the accused handed a firearm to Julius Malema. And the answer was, I will read it to you. Sorry, I need to find the right place.
No problem.
Okay, got it. The state's reply was, the cartridge found on the site after the event of the 28th of July 2018 was fired from the rifle with serial number SPA 249. The state alleges that the rifle was handed to Mr. Malema by accused number 2. You understand? That is what the further particulars say. When I last looked at the law, the state is bound by that answer. But in any event, I want you to comment on the provisions of Section 120 of the Firearms Control Act of if there is no evidence that he physically handed the firearm to him, this phrase in any other manner gives possession of a firearm.
So,
and how far back are we going? Are we going back to the manufacturer in Narinka?
Your Worship, first of all, I think it's subsection 10, bracket small a.
Yes.
Yes. Firstly, there is no definition in the Act of supply or possess. I've just checked that as you were asking the question. To give an absurd example, if I may, and speaking from experience, if one had to take a large security company that has many thousands of firearms, and there are quite a number of such security companies, to use this section, well, I have never seen this section used in my experience over 20 years to charge the owner or even the responsible person with such an offence. What almost invariably in my experience would happen is that the point of contact between the police and the license holder would be the responsible person. One of the primary functions of the responsible person is the keeping of up-to-date and accurate records. Excuse me. And there are registers specified in the regulations and how they are to be maintained. The police would then inspect those records and go through the chain of possession or use that those records specify. And they would then go to the person whomsoever those records specify as the last person who used or possessed that firearm. And then it is that person that is either asked to provide a statement or is charged with an alleged offence. And if I can just take it one step further, I've acted for many large security companies, and I cannot recall where the owner, the owner or director has been charged with this type of offence.
Let's use an absurd example. Fidelity probably got hundreds, thousands of guards. Who knows how many firearms? Any one of those guards does something wrong, the owner will be charged because he, in some or other manner, gave possession of the firearm to the guard.
Well, that's the absurdity that I'm referring to.
In any event, the Firearms Control Act makes provision, does it not, for a person who has a license for the firearm to hand it to somebody who doesn't have a license?
Yes, there's a number of reasons for that. I think it's section 22. Yeah, section 22 of the Act. And, Your Worship, to give a simple example, if I may, the Act provides for this simply because for a person to obtain a competency certificate, they are obligated to handle and discharge a firearm. So you can't use and possess a firearm without a competency certificate, but in order, for example, to be trained, the training provider allows you to use their firearm under their supervision and control. That's the requirement of the Act. And there are many other examples where that would happen. For example, on a shooting range where someone wants to test fire a firearm, that is specifically provided for in the Act. It's called demonstration and display. Where someone wants to engage in a sports shooting competition, for example, many shooting associations provide firearms for that purpose, and they're used under the supervision and control of an official from that body. And a simple example, which is a fairly common example as well, is if someone wants to go hunting, they use somebody else's rifle in their presence and control when they go hunting. It's very common.
Now, we apply what you regard as your testimony to this particular matter. And I must add from the outset that we will need comprehensive ballistic evidence to show that the firearm in question did not fire the cartridge case. So what I'm now putting to you is based on the premise that the state's evidence led so far is correct. You understand?
I do.
This particular firearm, according to all the records, of Skander and Lieutenant Colonel Janssen, who did a inspection, was in the possession of a person, I'll call him Mr. L.M., a security guard employed by Tactical Security Company. So, you understand that?
I do. It was signed out to him, in other words.
It was signed out to him. Mr. Nduli was the responsible person at the time. That is not only that document I showed you, but also the evidence of Lieutenant Colonel Janssen. Now, who would be the responsible person for this particular firearm?
Your Worship, we need to draw a distinction between responsible person as contemplated by the Act, which is a specific individual, and who is responsible for the firearm, which is different.
Okay.
So the person who is responsible for the firearm would be the person to whom it was signed out from the daily working register and who had the temporary authorization to possess that company firearm. That is the person that the police ordinarily, and in my experience almost invariably, would hold accountable for any misuse of that specific firearm. And I'd like to add as well, bearing in mind that I was involved in the genesis of the Act, that was always one of the principal purposes of what became Regulation 21 of the Firearms Control Act, which is intended to enable the police or a regulator to ascertain who had possession and use of a particular firearm at a particular time.
You said there were two scenarios.
Well, the responsible person being the one in the police records, and then the person who is responsible. I'm speaking about the person who is responsible, not the responsible person.
Do you think under these circumstances, if I may ask you this, if you don't want to answer it, say Mr. L.M. did something with a firearm, fired a shot at his girlfriend in anger, do you think Mr. Julie would be held responsible in law for that?
I think I've answered that. I've said that the starting point for an investigation would be to go to the responsible person. But then that the records that are required to be kept in terms of Regulation 21 and Regulation 22 show the chain of possession and custody, and ultimately the individual security officer would be held accountable.
That's the purpose of this regulation.
Absolutely. And I want to emphasize that, again, in my experience, where I have conducted many criminal trials, I've represented accused based upon an offence committed with a business firearm. It is the security officer who had possession that is charged. The only time a responsible person might be charged would be if there is improper record keeping in some way, and then that is covered by Section 122, I think it is, which deals with administrative fines. In other words, it's an administrative issue, not a criminal issue.
You have read the ruling in terms of the Section 174 application before this court, is that correct?
I have.
Of course, worship is very entitled to, it's a discretionary matter, to refuse a 174 so desire. But I want you to comment on this ruling by the court in terms of our Section 174, if you are able to. If you don't want to, just tell me.
Would you like to read me the part, please?
I'll read it to you. It says it comes, I'm reading from page 26 of your worship's ruling, from line 17. It says it comes down to the fact that count 4 and count 6 remain a statutory offence. It was confirmed in the evidence so far presented by the state that the firearm in question, being SPA 249/14, is indeed your firearm or the company's firearm, then inaudible, I should put it in that manner. The cartridge that was picked up at the scene or close to the stage after the incident is linked with microscopic ballistic analysis to SPA 249/14. Much emphasis was placed on the fact that none of the videos or witnesses testified that they saw you, thinking about accused 2 now, handing a firearm to Mr. Malema, but that is not the charge. The charge is, and I will read it for clarity, it is much wider. It is unlawful supply or in any other manner give possession of a firearm or ammunition. Being the Narinka firearm and a Remington bullet to accused number 1, so the actual not seeing or handing over is not a requirement in terms of count 6. It is supply or in other manner give possession.
With respect to worship, first of all, the firearm could never have belonged to an individual for 2 reasons. The first is that the license holder is Tactical Security Services. and that is a separate legal entity to any other corporate or individual person. Secondly, it goes back again, and Your Worship, I say this with respect, to the absurdity of the interpretation of the Act, because it seems so literal and so strict that you could say that the manufacturer could be held liable for making and supplying the firearm to a wholesaler who sold it to a retailer who sold it to a company or an individual. That is not the purpose, in my opinion, or the intent of the legislation. And I have never seen such a charge. I said earlier, I've never seen such a charge other than in circumstances where there was some form of direct interaction between the parties.
If I may move on to what is termed a blank gun. Sorry, Your Worship, mine just confirmed with this study. Is it, I'll ask you this, is it correct that you were shown we were probably having difficulty, Your Worship, of bringing this into the court premise? We'll see if we can, we had that agreement, if Your Worship will recall, that if we wanted to bring any firearm in, we would notify everybody before the time. And
I think the agreement was you'll clear it with all the relevant parties.
you were shown a firearm, is it correct, what is called a blank gun?
I've seen many blank guns. I haven't been shown specifically one for this matter.
Oh, sorry, I thought they'd shown.
No, I haven't.
I speak under correct. These blank guns, are they required to be licensed?
I'm going to say a very simple no, Your Worship, because they are sold without licenses, and the National Prosecuting Authority and the police accept that such sale and possession is lawful.
You are aware from the National Director of Public Prosecution, I think Advocate
The cock.
Tik Tok, he was the author thereof, in which he notifies the police that no prosecutions must take place for these firearms.
That's correct. I'm aware of it. If I can just add as well that it follows that the possession of the ammunition used in those blank guns is lawful as well.
Well, we have a ballistic expert that's going to testify about this particular gun. I would have liked to have shown it to you, but we will leave it at that. If it becomes necessary during the cross-examination or the re-examination, I will ensure that I get permission to bring it in here, because it's going to be obvious to everybody that one cannot distinguish between the real one and blank.
Your Worship, as I indicated, I've seen a number of blank firing objects and their ammunition, And although I'm not a ballistic expert, I own a large number of firearms. I'm an enthusiastic shooter and firearm collector, and I cannot distinguish between a blank firing object and a real firearm. They're in fact designed both in terms of appearance and their mechanical working abilities to be exactly the same as a real licensable firearm.
Thank you, Mr. Butler.
Thank you.
Sorry, just one further question my colleague has pointed out to me. Were you aware that Mr. Snyman was not a member of Tactical Security Services in 2018?
I've checked my records, and the member was Clement Nduli.
Thank you. Sorry, could I just request that you use call?
Yes.
Sorry, I forgot to apologize for the accused being late. They had in fact gone to a different court. The accused want me to apologize on their behalf.
Thank you. Advocate Odes, cross-examination?
May I approach my client sister?
Certainly.
Excuse my back. I have no questions for this witness.
Thank you. Advocate Caesar, cross-examination? You need a minute? Do you
Yes,
ready?
Your Worship, may I just request a brief adjournment? One, I want to make a copy of the document that was at Advocate Matthews's disposal for all the parties involved. Number two as well, I just want to also make a copy of the document they refer to about the NPA, Advocate de Cox draft. I do have
Draft.
in my possession. I'll just make copies for everybody.
Thank you.
So the
No
adjournment,
objection.
adjournment will be half an hour, Your Worship,
Half an hour.
or June.
It's up to you. I'm in my office, available. The only other concern that I would like you to clarify on, and this is the crux of the matter for me in this regard, is you yourself testified, you've been internationally recognized. I don't take that away from you, and I don't question your opinion in any manner. However, it is your own words when you were asked to read that section. It's extremely wide. The Act doesn't define. The Act doesn't define possession. The Act doesn't define. But you can't limit yourself to give your view based on the set of facts we are dealing with here today.
Your Worship, in 2022, the Constitutional Court gave a decision relating to certain provisions of the Firearms Control Act. And in that decision, they referred to a reasonable and business-like interpretation of legislation. I'm guided by that as a legal practitioner. So in my opinion, the version postulated by the state in the formulation of the charges is neither reasonable nor businesslike in the circumstances of this case. That is my opinion.
In a nutshell, in your view, is section 120.10a then null and void?
No,
Serves no purpose.
no, Your Worship. We all need to take into account that we can't quote the section piecemeal. It says who is not allowed in terms of this act to possess that firearm or ammunition. So it's linked to a very specific requirement.
Yes, exactly. I agree. So, do you have an opinion on the set of facts that you've been, I'm sure, presented with during consultation by the defense? Because I've not heard you on that aspect.
Your Worship, I do not know the full facts of this matter. I have not seen the video for a number of years. That was not the purpose of me being called to give evidence.
So I'm going to leave it at that. Thank you, Mr. Woods. No, not yet. Sorry, there's a second phase to this. Advocate Matthews, questions based on the court's questions?
I refer you to the further particulars in the matter. It bound itself. These are the facts. The state has bound itself to the handing over of the firearm by accused number 2 to accused number 1. You understand that, yes? And I've referred you to the section 174 where Her Worship said in her judgment that, sure, there is no evidence that there is a physical handing over of the firearm, but because the section says may give possession in any other manner. All right. Now, I fail to understand what other facts you've been given, the Worship is asking you, to show that the firearm was handed over in any other manner. Have you been given any other fact?
I think he was quite clear on that, Advocate Matthews, that he was not at the end of questions by court.
No, the guest of the Worship's question is a little bit different to mine with respect. The state is bound by what it says in its further particulars that there was a physical handover of the firearm. All right. The fact is, there's no evidence as to that before this court. You understand? I do. Now we're going to this interpretation of this or in any other manner gives possession. And Her Worship in the judgment says because he was the owner of the company, all right, that means that in any other manner he gave him possession.
Sorry, can you just refer to the page where I said he was the owner of the company? I just need to update myself as well. Thank you.
Yeah, paragraph 20, page 25 of your ruling, line 19. The firearm in question being SAP 249/14 is indeed your firearm.
Yes.
Or the company's firearm.
So the word being the owner of the firearm was not uttered by court.
The firearm in question being SAP 249 is indeed your firearm.
Did I use the word owner?
Or the company firearm.
Did I use the word owner?
No.
Thank you.
Right. That is the the words used by the court. Your firearm. Or the company's firearm. Now we established that it's not his firearm. All right. And the firearm belonged to a close corporation, as you understand, yes. All right. Now the mere fact that the owner, in brackets, might be present on a scene where somebody uses a firearm belonging to the company, would that mean that in any other manner he supplied it to? No. Thank you.
Thank you, Advocate Matthews. Advocate Odes?
Bishop, I have a few questions.
Certainly.
Arising from the Bishop's questions that they relate to the ammunition. The Bishop asked you whether the ammunition for the blank firearms is available to buy in South Africa. Do you remember that? Yes. Now, what I want to put to you, sir, is that usually the blank firearms and the ammunition are sold together at the same type of retail stores. Now, you also said that you don't need a license to purchase these firearms, you don't need the competency to purchase a blank shooting firearm. I want to put you that the same would stand in relation to the ammunition. One doesn't need a license or a competency to purchase the blank ammunition. Is that correct?
Well, correct, and in fact, technically, according to SAP's ballistics, it's not ammunition.
Yes.
Well, I have an issue there, and I want to show it to you because everybody's handed in or had regard to Exhibit L2, and there seems to be some uncertainty in that regard. If I may refer you to the last page. Do you have it before you?
Is that the Cox?
The advocate, Rodney de Kock.
For some reason, I don't have the last page.
Well, it doesn't seem to have a last page. But
Mine ends at paragraph 18.
The other one that I have as well. No, I've only have it up to 18, so I have this from my learned friend for the state. But if you look at paragraph 17, it's been circled by somebody, the DPPs are also of the view that even though the blank ammunition can technically be regarded as ammunition, in terms of the FCA, that the possession of such ammunition cannot be prosecuted based on the fact that the general public is informed that no license is necessary to possess such. So my question to you is, you said that, and I understood your definition of ammunition being ammunition that actually sends out a projectile. Here, this ammunition doesn't have a projectile, so but they say technically, even though it might fall within the definition, it's not an offence to possess it.
That's the Director of Public Prosecution's opinion. SAP's ballistics have issued a directive saying it has to have a projectile in order for it to be ammunition, to fall within the definition of cartridge as set out in the Firearms Control Act with those four components: primer, propellant, case, bullet.
Now, my next question, sir, relates to the more recent debate that took place. If one has regard to count 6, and I'll read it to you, that's the section 120 sub 1 sub A. Then to read it, it's in its entirety to you, and I need to tell you up front, it only applies to accused 2, but it makes mention of accused 1, so that's why I want to make that clear. So it says here that count 6, accused 2, that the accused is guilty of the offence of contravening the provisions of section 120 sub 10 sub A. We have the sections 1, 103, 121A, it's section 121. We have the Schedule 4 and Section 151 of the Firearms Control Act 60 of 2000, and further read the Section 157 of the Criminal Procedure Act 51 of 1977. Then they identified as providing a firearm or ammunition to any person not allowed possessing it. Now I need to clarify this because they say further here, when they explain it in the body of the charge, and that upon or about the 28th of July 2018 at Adon Miasisa Dukazi Stadium in Dansani in the Regional Division of the Eastern Cape, the accused that unlawfully supply or in any other manner give possession of a firearm and ammunition to it, a .223 Narinka rifle and or a firearm, the maker of the firearm unknown to the state, and a .223 Remington bullet to Julius Malema, being a person who is not allowed in terms of this act to possess that firearm and the ammunition. Well, I understood your evidence, and this is why I ask you this, to be a person who's not allowed to be, in terms of the act, in possession of the firearm and ammunition. On your reasoning, as I say, you must be a person who's been declared unfit to do so. Would that be accurate?
That's correct, yes.
Now the reverse, or not the reverse, the facts of the case as put to you were that accused number 2 has never been declared unfit to possess any type of firearm. Could that then apply on your interpretation of Section 120 to these facts in this matter?
If I understand your question correctly, and to put it in simple terms for me, are you suggesting it would be lawful for one accused to supply the other accused the firearm? Is that what your suggestion is?
I'm not suggesting. I'm using your evidence just to explain. As I understood,
I don't have the charge sheet in front of me.
I'll hand it to you. As I understand your evidence, and this is the point, is that possession is very, very wide, and you said in order to not be allowed to possess, because I can give my firearm to somebody else to shoot, but to make it an offence, that the person that I give it to would have to have been declared unfit to possess.
No, what I said was, in these circumstances as presented to me, because Mr. Snyman was present, then he, on the version of the state,
Yes.
and I want to emphasize on the version of the state, could lawfully hand that firearm to anyone in his vicinity where he could exercise control over that firearm.
I understand that. My point is the following, Mr. Wood. He could hand it over to anybody, and I put to accept a person who's been declared unfit to possess such a firearm, because that person by law is not allowed to possess such a firearm.
Yes.
So let's use the version of the state, okay, as was put to you. On the state's version, accused number 2, it goes against the further particular, but on the state's version, accused number 2 handed over a firearm to accused number 1. Accused number 1 is not declared unfit to possess a firearm. Is there anything improper or irregular in doing so in his presence?
Under his control, no.
But I emphasize that's the state's version.
It's
What's
a
the video?
hypothetical.
We've all got different, the same view of the video, which doesn't substantiate the state's version. But if you saw a video, let me put it like, if you saw a video of accused number 2 handing over a firearm to accused number 1 who had not been declared unfit to possess a firearm, would there be anything untoward or illegal in him doing so?
No, as long as the person handing over the firearm was in his presence and exercised control.
Thank you. That's how I understood you, and that's what I wanted to clarify. Thank you. Thank you, Ashok.
Thank you. Any questions based on the court's questions?
Just one or two. You wanted to state earlier what is the 4 type of competencies you got for different type of firearms. You said there are 4 types.
Handgun,
Yes.
shotgun, manually operated rifle,
Yes.
semi-automatic rifle, pistol caliber carbine.
Is it correct that you have to go for training to get the competency in respect of each of that type of firearms, except for the revolver and the handgun? They go for the same competency, is that correct?
Well, the training doesn't distinguish between types of firearms at all. So it's a rifle, it's a handgun, it's a shotgun, and it's a semi-automatic rifle or pistol caliber carbine. So you don't talk about a revolver or a handgun.
Yes. But the fact of the matter is they are not the same. The handgun, the competencies for the handgun and the rifle are not the same.
No, the training is different, yes.
I didn't hear your answer.
The training would be different, yes.
Correct. I did training for a handgun, a semi-automatic handgun. Can I now use that same competency certificate in respect of a rifle?
No. However, you do not need a competency certificate to use a firearm under the supervision and control of the license holder or someone authorized by the license holder.